Federal law allows citizens to reproduce, distribute, or exhibit portions of copyrighted motion pictures, videotapes, or video discs under certain circumstances without the authorization of the copyright holder. This is called fair use. It is allowed for purposes of criticism, news reporting, teaching, and parody, which doesn't infringe of copyright under 17 U.S.C. 107.
Welcome back to the channel, everyone. Have a video today that's about political power, what it's like to go up against those that are in power. Touches on the good old boy philosophy of politics, and it's basically a 75-year-old woman who's retired. She had some time on her hands. She wanted to give back to her community, so she ran for city council. She was elected. She listened to her constituents. They put a petition drive together to remove the city manager because they weren't happy with his performance. And lo and behold, that's where the story pretty much begins. And I'll let the attorney for this person define and set this story up, because she's doing an interview with John Bryan, the civil rights lawyer out of West Virginia, and she sets it up extremely well. So without further ado, let's let her speak for how this all evolved. Get a chance, tickle my algorithm, give me a like, dislike, comment, whatever helps my channel out. I really do appreciate it. Okay, here we go.
Sylvia Gonzalez, now she is 75 years old, a retiree in Castle Hills, Texas. She decided to give back to her community after she retired and run for city council.
I decided to run for my seat on Castle Hills City Council because I had the time and the energy to work. I got a very good response. I went to more than 500 residents. They complained bitterly about the city and that they could not even get a hold of anyone.
When she was campaigning, she heard a lot of constituents of hers, potential future constituents, complaining about the city manager and saying that they are not happy with him. And so she promised that if she were to get elected, she would champion a petition to call for his removal.
Because the city manager would not return their calls, their streets were not being fixed, they're my neighbors. See you later. That's what they talked about. They were glad to see someone that was gonna finally be able to do something for them.
So she got elected. She became the first Hispanic woman to ever be elected to the city council.
And I won.
Please raise your right hand and repeat after me.
By 53% of the vote.
Sure enough, as her first act of office, she spearheaded this petition to remove the city manager.
One of my supporters came up with a petition. I felt the petition was important because it gave my word a lot of strength.
And it just happened that Mr. Rapley is very good friends with a city mayor, with the police chief, and with a special investigator whose name is Alex Wright. They conspired to investigate her. Then she ended up having to spend a day in jail.
I went in and got handcuffed, I got frisked. They wanted me to put on this orange shirt, but I was cold and I had to sit on a metal chair. It was a very hurtful experience. And the sad part is I did nothing wrong.
So now you're gonna ask, what did they investigate her for, right? According to them, she misplaced a petition that she herself championed. According to them, she tried to steal the petition that she herself championed, that she herself presented to the city council by putting it in her binder.
My first council meeting, we were assigned to evaluate the city manager. You can share them now.
Objection.
because of all the turmoil and the hostility, they can never get you to return any calls. Lasted till after midnight. Please don't interrupt me. At the end of the second day, the second meeting, I just had all these papers, so I tried to gather them, and then I tapped them on the desk. And then I just stuck them at the top of my binder. The Castle Hills police captain comes over, taps me on the shoulder, and tells me the mayor wants to speak with me. I go over to the mayor, and he asks me where is the petition that was turned in. And I told him I didn't know where it was. He proceeded to tell me that he thought it was in my binder, that he could see a little clip. And I found the petition, to my surprise, and I handed it to him, and he said, "You probably picked it up by accident." And I thought nothing of it, but I was thrown in jail.
As one of the judges during the oral argument in the Fifth Circuit said, he said, "So if I take this judge's papers and place them in the binder, now you have probable cause to arrest me, is that right?" And the opposing counsel did not have a good answer to that, because there isn't a good answer to that. So they found this statute called tampering with government record. And they said that Sylvia, the grandma, basically, because she misplaced the petition and put it in her binder, that she is somehow guilty of tampering with the government record. Now, that's a Class A misdemeanor. Sylvia does not have a criminal record. She is a council member. This misdemeanor is a non-violent misdemeanor. So these kind of things, even if you thought that there was probable cause for her arrest, and even if you thought there was probable cause for her to have violated that statute, you don't throw people in jail for that, right? Jails are crowded as is. So what happens with non-violent misdemeanors is normally summonses are issued, right? Or you are at least allowed to get processed through a courtroom. But these three individual defendants did everything in their power, including circumventing the district attorney, to ensure that she would be thrown in jail and not just issued summonses. So really, there is a clear retaliatory motive here, right? They are investigating her for a month, and they're finding this broad statute to charge her with and put her in jail because she championed this petition to remove their ally, the city manager.
Okay, so there's quite a bit to unfold here. So the one thing about qualified immunity that she points out, if it's denied at the circuit court level, you know, you can go on up to the higher court. You can freeze everything and go to the higher court and get an opinion. And what's kind of shady about that, I mean, sometimes power becomes, for lack of a better term, less touchable the higher up you go. You know, you get some good old boy stuff going on. Now, they do claim that there's a pending Supreme Court case that pretty much, in their opinion, prohibits them from acting on it any other way. So that's yet to be seen. So getting the Supreme Court to hear it is a pretty big deal. I really hope that at some point in time we get some case law before the Supreme Court to revamp qualified immunity. I just don't want to see city administrators having the same qualified immunity that law enforcement officers have. It just makes no sense to me. They have time to conspire and to use that in their favor while they're acting in a corrupt fashion. It's just not good. All right, let's move on to this next bit.
That prevents us from allowing Sylvia's claim to move forward. But Nieves had an exception for exactly cases like Sylvia's, where if it's clear that the statute is used as a pretext, that generally officials use their discretion to not charge people under statutes like that, but they do it in this case because she spoke out, then in that case, probable cause is not going to be a barrier. They use an example in Nieves with jaywalking, and Chief Justice Roberts says, like, we know that jaywalking happens all the time, and yet people don't get arrested for it. So if all of a sudden a government critic gets arrested for jaywalking, then, probable cause for jaywalking shouldn't bar his claim. So the majority did not think that we fit within that exception. So after that, we filed for en banc review. Your listeners and viewers will know that that's when you ask the entire circuit court to rehear the case. The en banc review was denied, but 6 judges out of 16 would have voted to grant en banc review. And another judge joined Judge Oldham and wrote a separate dissent. And just like Judge Oldham, he said, government machinery should not be weaponized against government critics, and that Sylvia Gonzalez's claim should be allowed to proceed. Here's what's really interesting about it and why we are petitioning to the Supreme Court. There is a circuit split on this. As you know, that's one of the biggest reasons why Supreme Court picks up petitions. We're taking those 2 dissents from Judge Oldham and from Judge Ho on how government shouldn't be punishing their critics by weaponizing the machinery of the government. And we're also taking Justice Thomas's statements against qualified immunity, where he says that it shouldn't be a one-size-fits-all doctrine and that on-the-beat cops should have a different level of protection than desk-bound bureaucrats. We're taking those things, we're putting them in our petition for certiorari, and we're submitting that petition to the Supreme Court, asking it to overturn the Fifth Circuit and hold that when you have obvious evidence of retaliatory animus, right? When you have that obvious evidence like we do here, then even if there is probable cause for arrest, like often there will be probable cause for jaywalking, to be arrested for jaywalking, right? That probable cause shouldn't bar First Amendment retaliation claims. Otherwise, it just becomes censorship, backdoor censorship, where they can't pass a law saying you can't criticize me, but they can throw you in jail so that person knows not to criticize you in the future, right?
This is something I've worried about before, and I've had lots of clients that have worried about it. Like, if I come forward, if I file a lawsuit, what if they retaliate against me? And it's if the law is that all they have to do is get them on speeding, and then if theoretically they can arrest somebody for speeding, whereas they usually wouldn't. If that's legal for them to do that, just to retaliate against somebody, and you can't file a lawsuit about it, I mean, that seems to be a bad thing. So yes, I'm glad you guys are taking this on.
You're not alone in that, right? Justice Gorsuch, he wrote a concurrence in that case, Nieves versus Bartlett, that announces this probable cause rule. And he said there that, everybody breaks laws on a daily basis these days, right? It's just we have so many criminal laws on the books that you can find anything to get somebody for it, right? And you really don't want that to be available out there for government officials to punish government critics, right? We don't want speech to be suppressed in those kind of circumstances. And frankly, this rule about split-second having these rules to protect split-second decisions kind of makes sense, but not more than that, right? So let me describe you like a split-second scenario that Nieves versus Bartlett deals with. There you have this festival Burning Man festival in Alaska, and you have this guy, walking around essentially telling people to not listen to the cops, and the cops are walking around and telling people to not drink, or like to make sure that there is some sort of order in this festival, and it's a chaotic situation. These two police officers are trying to keep it under control, and you have this guy basically shadowing them and telling people to don't listen to these guys. They can't tell you that, right? So one of the police officers ends up arresting this guy, and the guy sues for First Amendment retaliation, right? And there the situation is much more difficult because it's a split-second type of decision making.
Chili's from Alaska. What do you think, people? It could have been him. That's his MO. This clip's from Houston, where he was in cops' faces down there. And then I've got a little clip I'm running right behind this that's from the Memorial Day parade up in Boston with Kate. Here it is.
You to leave me alone. I just said don't follow me around. I'm not hanging out with you. Cops are bad people. Cops are the worst people in society. Remember that. Watch your back around cops. They're terrible. They're terrible.
He was creating problems for these officers to enforce the law in the moment, right? And his speech, when he says, don't listen to these police officers, that speech is part of actually obstructing police officers in performing their duties. So there, how in the world are you supposed to distinguish between, oh, that was probable cause that made them arrest the guy, versus, oh no, that was his speech that made them arrest the guy?
Why don't you just go? On the sidewalk. You're causing the problem. Everybody's on the sidewalk. Listen, this is what I do for a living. You are the problem right now. Why don't you just go? You're clogging traffic. Why don't you just go? The problem here is you. Get the fuck out the way. The problem here is you. Just move along, copper. Bro, you're blocking traffic. Just move along. Stop blocking traffic. Listen, I got 3 civil rights lawsuits this year. You'll be my 4th. Arrest me for no reason. Listen, you filthy pig. Just move on, dude. You're the problem.
It's pretty much impossible to disentangle the two and figure out whether it was proper or improper motive. So I get it. If you think that probable cause is a useful proxy in that type of a situation, that seems reasonable. But if you go beyond that, right, and think all of a sudden probable cause is a useful proxy, even though you have ton of other evidence showing retaliatory motive, right? Over the period of months, they investigated Sylvia. They did everything they could to ensure that she would be in jail rather than simply issued summons, right? That nobody in Bexar County was ever arrested for this kind of behavior before. We have so much evidence that helps to untangle probable cause from improper motive that then the value of probable cause as a proxy plummets. It doesn't tell you anything anymore. So at the very least, that kind of probable cause rule should be limited to split-second decision-making. And desk-bound bureaucrats certainly shouldn't be allowed the same level of protection as somebody who is making split-second decision-making in a very difficult and uncertain type of a situation.
There we go. There we go. She's very well spoken. I really like the way she's laid this out. So qualified immunity should not be available to the bureaucrats the same way it is to law enforcement officers, plain and simple. Cops are out there making split-second decisions. That's kind of what qualified immunity was designed for, to protect them when they find it is a lawful act. But how in the world did our city administrators and such How did they manage to become eligible for qualified immunity? There's just no way that should be. And look, there's a lot of well-run municipalities out there and county governments and so on and so forth. Of course, counties, most of those are elected positions, so that's how you take care of that. And some of the city is too, but there's a lot of appointments in municipalities. There's just too much corruption, or the temptation for corruption, if they know that they do qualify for immunity. So this is really, really good argument. It's going to be really interesting to watch. I think she said April 20th, which is just a few days away, is the day they're going to file it. So it's going to be moving along here. I'm going to try to keep a close eye on it, and I'll keep my channel up to date on this case. So I really appreciate if you've made it all the way to here. We're almost to the end, and I really appreciate those of you that have stayed in here and paid attention to this, because it really is important. People need to become vocal about qualified immunity, not abolishing it, but revamping it, restructuring it, tighten up the guidelines. Let's make it useful for the police that are out there, performing, not for our bureaucrats. All right, people, thank you so much for coming. Help my channel out if you can. If you feel like it, leave a comment. I try to get back to the comments, good or bad. I'm proud of Ram. And once again, thank you for everything. Love you guys. And I'll be gone.
Yeah, I can see this popping up in a lot of the middle finger cases where somebody's driving, they flip off the cops or something like that. Because
Yes.
I could see some good First Amendment retaliation claims coming out of those, but also the same defense where maybe the guy actually was speeding, or maybe there was a brake light out, something like that, where so they arrested them or charged them really subjectively because they didn't like their speech, but objectively they did commit that traffic violation. You guys do a good job of finding the perfect plaintiffs here, because everyone should be able to agree that somebody like Miss Gonzalez, who literally had done nothing wrong, and you couldn't find better defendants than these city officials who are planning and plotting behind the scenes and conspiring to sort of put her through their local criminal justice system. I mean, it's an ideal case.
How can possibly this woman present a threat, right? They are basically arresting her. The way they're doing it, they're circumventing the district attorney, right? They're using this loophole specifically for violent individuals or for flight risk people. And here you have this grandma, the most adorable, peaceful lady with not even as much as a traffic ticket to her name. And somehow this is a non-violent misdemeanor. And even if you did believe it was true, and somehow you end up thinking that this is the person worth being thrown in jail. At the time when jails are overcrowded as is, they couldn't find a worse person to throw in jail. I don't know what the hell they were thinking. But fundamentally, though, they succeeded because, Sylvia was so discouraged by what happened to her. She stepped down from the city council, and she's not politically engaged the way she was before. So, if qualified immunity protects these guys, then in a way they succeed, which would be absolutely ridiculous and contrary to common sense.
This is textbook First Amendment retaliation, because what you have to prove is that they're doing something that would chill free speech. And that's exactly what they did. Not only did they chill Sylvia's free speech, but they also chilled the free speech of other people who saw what happened to her and had any ideas or thoughts about trying to change things themselves. They completely suppressed any opposing speech.
Yes, and it's they even say in the decision that we sympathize with Ms. Gonzalez, and her claims are very strong in that she's alleging that she was silenced. But there is nothing we can do because of this Supreme Court precedent. And that's just not true. It's not that there's nothing they can do. They could have interpreted this commonsensically. And that's what qualified immunity allows judges to do. Just basically say, we're very sorry. There's nothing we can do. Our hands are tied. Even though we see this injustice and it's obvious and it's clear, we really don't have much discretion here, and we have to deny your claim.
What's the time frame on this?
We are filing our petition on April 20th. There are a lot of amici who are interested in supporting us, public interest organizations and professors and former police officers who are interested in the case and want to support our cause. And they will file their briefs as well. And then, it will be up to the Supreme Court to see whether to grant it or not. And, here you really have an acknowledged circuit split, which often you don't, right? We usually try to convince the Supreme Court. There is really a circuit split. If you look at it just right, you can see that there is a disagreement. But here you don't need to look at it just right. The Fifth Circuit is acknowledging that it is disagreeing with the Seventh. And it really is a great case for the Supreme Court to really grapple with this idea of why probable cause is useful and what are the situations when probable cause is not useful and is just an excuse to silence somebody. So we hope that they will give it a fair consideration and grant